In Chapter 8, you have illustrations of the professionals and the roles they play in the courtroom. Your book dichotomizes between both the professional work group in the courtroom and those external players who are just as important, but they are not professionals who work in the courtroom on a daily basis. Let's begin by discussing the role of the judge. I would like for you to think of the judge as the referee, and it is the judge's responsibility to rule on issues that come before him in the form of motions. For example, a defense attorney files a motion for continuance, which means that he or she wishes to delay the trial for a period of time. They will file a motion, that is a document that is placed in writing, requesting why they need the continuance. The judge then will have a hearing. Generally, Fridays in this country are motion days, and if you go to any circuit court or federal court, you may find the prosecutor and the defense attorney in there discussing the motions that have been submitted to the court. Usually Friday mornings is when judges will take care of this. Then the judge will bring in the defense attorney and the prosecutor. If the prosecutor refutes the defense attorney's motion, there will be a hearing, and the judge then will listen to both sides and will make a decision whether or not the motion will carry or the motion will be denied. This is a particular important part of the judge's responsibility. Also, the judges will interpret law. That is, if an issue of law comes up during the trial, the judge will dismiss the jury and will have a hearing. It is a formal hearing. The court reporter will be there, and the judge will hear the argument of the defense attorney and the argument of the prosecuting attorney on the point of law in question, and will make a decision at that point. Then the trial will carry forward, or if the motion was a point of law to dismiss, then the trial will be dismissed. The more important issues in regards to the criminal trial will be the discussion of admissibility of evidence, and that is, if the evidence is challenged either by the defense or prosecution, it is the judge who will ultimately determine whether or not that evidence is going to be allowed at the trial. Last, the judge may determine guilt or innocence. It is the defense or the accused option to have a bench trial or a trial by jury. If it is a bench trial, then the judge will determine guilt or innocence. The last responsibility of the judge before the trial evidence goes to the jury for their deliberation will be the jury instructions. This is where the judge will tell the jury exactly what the elements of the crime are in question. They will give definitions of beyond a reasonable doubt by a legal standard, and they will address the various levels of punishment. For example, if you find a person guilty of first-degree murder, this is what you may give as his punishment. If you find him guilty of second-degree murder, etc., etc. Every jurisdiction will have a number of trial court judges, and they will then either rotate this position or one will simply accept it depending upon how the Constitution is written and keep it till he or she retires, and that is the role of the chief judge. Please know their responsibility. We discussed judge selection in the previous chapter, but again, in the federal courts, you are nominated by the president and appointed by the Senate for life. In the state courts, you are elected. And in general, if it is a court of limited jurisdiction, it is a 4-year term. General jurisdiction is an 8-year term, and appellate reviews are 12-year terms at the state level. When a judgeship position is vacated, illness, death, or the judge has decided that he or she is going to step down, then I want you to read the Missouri plan. Most states will utilize this, and to fill that vacancy, there will be a list of candidates that will come from the local bar in the county where the judgeship has been vacated. The list will then go to the governor, and the governor will appoint the person to stand in until the person who stepped down elected time is over. For example, if it is an 8-year term and the judge stepped down in the 5th year, then the appointed judgeship will replace her for a 3-year period. At that point, if they decide to stand for election, they are allowed to do so. The judge's qualifications, as stated in the previous chapter, but this is a good review. For a judge at a general or appellate review level, they must obtain a law degree. It must be from an accredited law school. They must be a member of the Bar Association in the county or within the state that they are applying for election to. And most recently, that is given the 70s, they now must attend professional training, which is conducted at the University of Nevada's campus. Moving on to the role of the prosecutor, it is not the chief of police, but it is the county or federal or attorney general, both at the federal or state level, who is the chief law enforcement officer of the nation, of the state, and of the county respectively. It is the prosecutors who determine what charges are going to be given as indictable offenses. It is the prosecutor who, at the very initial stage of review, will determine whether or not the person is going to go through the justice system, and it is the prosecutor who will determine how far that person will go through the justice system up until trial. The prosecutor selection process, if it is a state prosecutor, that is Attorney General, or the county prosecutor, they are elected, and they are elected in most states to a 4-year term. At the federal level, the federal prosecutors serve at the will and pleasure of the president, which means that they are nominated by the president, approved by the Senate, and then they are seated as the federal prosecutor within the region they are assigned. However, when the politics change, for example, in the up-and-coming national election, we probably are going to see more Democrats take positions of high authority and power, especially the presidency. And if this occurs, you are going to see an en masse evacuation of federal prosecutors, as they will then be replaced by prosecutors nominated from the Democratic side of the House. You will see the importance of the political theme throughout the administration of justice. I think this becomes especially transparent as we review and examine the role of the players in the courts as to the politics involved. The responsibility of the prosecutors at any level, be it federal or state, would include the presentation of the government's evidence against the accused. And when a prosecutor decides to indict, they are looking at evidence that, when you consider it as either a judge for a bench trial or a impaneled jury, the burden of proof must be beyond a reasonable doubt. And that is in their mind as they make their decision as to whether or not to go to trial. Federal and state prosecutor offices will also have assigned staffs. For example, the federal prosecutor's office will have a number of associate and assistant federal prosecutors that they are responsible for supervising, and the same holds true for county prosecutors. Generally, in a prosecutorial office, you will have a number of attorneys who serve as the prosecutors in the courtroom. You may have a number of investigators. Usually these are retired police, or they are police who have been hired at either the federal or state level and assigned to a prosecutorial jurisdiction to do investigation on the cases. They will follow up on the police reports and do further, more intensive investigations as they prepare the case for trial. The police and prosecutors are independent. However, the prosecutors do act as a legal advisor to the police, and in jurisdictions where you have a good working relationship, then you tend to have a significant, successful community in terms of law enforcement and prosecution. But if the police and the prosecutor do not get along, then you can have problems in regards to prosecuting a case, because it is the police who originally give the information to the prosecutor on the complaint. Then it is the prosecutor, based on reading the complaint, the police reports, and most likely interviewing the police involved, will decide whether or not the police acted in a constitutional manner in searching the car and not acquiring a search warrant to search the house, etc. Ultimately, it is the prosecutor who will decide who is going to go through the justice system and how far, not the police. It is also the role of the federal and state prosecutors to represent the state on cases of appeal. For example, if an issue of a search warrant has been raised on appeal and the motion is before the state Supreme Court to deny the constitutionality of the search, then it is the prosecutor who will file a motion and will also be present then to represent the state in regards to the hearing as to whether the search warrant was indeed constitutional. So on the one side you have the defense attorney, on the other side you have the state, which generally is going to be an assistant to the U.S. Attorney General or State Attorney General's office or the local jurisdictional prosecutor, who will handle the appeal on the state side. Because this is the essence of the prosecutorial responsibility and that important word discretion, I'm going to read in toto what the prosecutors will decide, and this is from your text. First, they will decide whether or not to charge someone with the crime. Again, it is not the police, it is the prosecutor who is going to determine the charges. Also, obviously, they will determine what charges to file against an individual. Further, while they do not control the court calendar, they will decide when to prosecute for trial. If they don't indict, they can continue to investigate, and it can be years after the initial complaint has been filed by the police before the prosecutors will decide that they are going to or are ready to indict. They will decide whether or not they are going to accept or even begin to negotiate for a plea bargain. And remember that statistically, depending upon what articles you read, 80 to 90% of all of the cases that reach the prosecutorial stage are pled as a guilty plea. And then, of course, if a plea is not reached or if the prosecutor is not going to negotiate, then they will decide what evidence they are going to use, what witnesses they are going to call, etc. In the sentencing phase, the prosecutor has an obligation, a legal duty, to make recommendations as to what they believe would be the acceptable penalty. If it is a crime that is mandated to a sentencing guideline, then the discretion is taken both from the prosecutor and the judge in that regard. Please read the Brady case, Brady versus Maryland. This case, the Supreme Court mandates that if the prosecutor has in his or her possession exculpatory evidence, then they must give that exculpatory evidence to the defense counsel. Exculpatory evidence is that evidence which will exonerate a individual accused of a crime. Why would they not do that? When you have prepared literally hundreds of hours and spent thousands and thousands of dollars in preparation for a trial, and a piece of evidence comes across or appears that would be exculpatory in nature, human nature may dictate that you are not going to present that to the defense. If you do not, as a prosecutor, that is a serious ethical violation which can lead to your disbarment and possibly criminal conviction for yourself. As you go through the chapter, remember that the players for the state, both the prosecutors and the judges, are totally immune from civil suit. Corresponding to the Brady case is U.S. versus Begley. This is a case where the Supreme Court has said that justice is not a game, and the court ruled that the prosecutor must disclose any evidence in his or her possession that the defense requests. In other words, the defense is going to ask the prosecutor, okay, so what evidence do you have against my client? Because how can I put up a defense if I do not know what evidence you are going to use against him or her? The court's agreed with the defense and has mandated that the prosecutor must disclose any information that is requested by the defense attorney. For example, a list of witnesses, any and all physical evidence that is going to be used, the test of those physical evidence in terms of results, etc. What the case give the prosecutors immunity, and that immunity is absolute from liability. There are two. Because prosecutors have such power, there are instances and many of abuses of discretion as they wield that power, or perhaps better stated in not such a pejorative term, as they administer justice in their county or region. Prosecutors, when they get in trouble, it will generally be in these areas. One, not prosecuting friends. Think of it in regards to politics. If the chairperson of the Ohio County Democratic Party has just been arrested for DUI and all of the material in the case, including the arrest reports, disappear at the prosecutorial office, that's a problem. Along with that, accepting guilty pleas, as your book suggests, or significant reductions of charges for clearly what becomes personal advantages or accommodation to friends. Although difficult to support, there is a discretionary problem that charges can be brought if a person can prove that the prosecutor was simply trying to get their names in the paper because it's now time for re-election, so you have an overzealous prosecution or level of prosecution. But as I say, these are difficult to prove, and of course discriminating against minorities would be examples of abuse of discretionary powers from the prosecutorial office. As you read these in your text and you reflect upon them, you can see that many of these would be simply an interpretation of the prosecutor's behaviors, and it is very difficult to have a smoking gun, if you will, in these particular types of claims of abuse of power. Prosecutors are expected to abide by and follow the American Bar Association model rules for professional standards relative to the prosecutor and his or her professional activities. Because our system of justice is adversarial, that means that you have two sides that go to battle. Then if there is a prosecutor, there is going to be a defense attorney or counsel at every hearing, every trial, and it is the defense counsel who is going to represent the accused. Defense counsels must have a law degree from an accredited law school, and they do not have to be a member of the immediate bar in the county or region, but they do have to be a member of a bar. Obviously, they represent the accused at all phases of the criminal justice proceedings. They are the ones who are very much involved in the plea negotiations. When plea negotiations fail or are not offered, then it is the defense counsel who will prepare for a defense in trial. And if they are not meritorious during the trial and their client is indeed found guilty, then they will also participate in the arguments concerning the sentencing of their client. It is the defense attorneys who will initiate appellate review proceedings. In many instances concerning the appellate review process, the attorney who took the case to trial will not be the attorney who files the appeal, because many accused are indigent, and as they were poor entering the trial, they are not going to be any better off financially after the trial. So if there is an appellate review, it is most likely going to be by a court-appointed attorney to do the appellate work as compared to the court-appointed attorney who did the trial work. But most likely they will not be the same individual. The categories of defense attorneys used in this country are of the following three. The first is an attorney who is acting on behalf of his client as being paid fully for his or her services. An average attorney will make $200 to $250 an hour in performing advocacy work for their clients. Of course, this can be negotiated, but as I read on a national level, it is between $200 to $250 as a median for an hourly wage that the private attorney will receive. The second is the court-appointed attorney. This is an attorney who the court asks to represent the indigent client, that is one who cannot afford an attorney, and they will receive, in West Virginia, they will receive a much less compensation than they would if they were acting as capacity of a paid attorney. The state pays anywhere from $30 to $50 an hour, whereas if you are private, you would get $200 to $250 an hour or more. So when you are assigned an indigent case, you are actually losing quite a bit of money because there are only so many hours in a day that you can work. But the courts do assign court-appointed attorneys to indigent cases, and you are expected to act on their behalf as the same as you would being paid a full hourly wage. The third is the public defender. These individuals are paid by the state. They are not high-paying positions. They tend to be filled by individuals who are out of law school. These are excellent positions to get a lot of experience in the courtroom, and they will have significantly large caseloads. So you have the private attorney who is paid a handsome hourly wage. You have the court-appointed attorney who is paid by the state at a much lower cost. and you have the public defender who receives an annual salary. Because many individuals accused of crimes are indeed indigent, there are several significant landmark decisions that I want to discuss. First of all, I want you to know the requirements of the Sixth Amendment, which says that you are guaranteed a defense, which has been interpreted to mean that as a defendant you have the right to effective assistance of counsel. Remember that term, effective assistance of counsel. Defendants then who are indigent will have attorneys, either court appointed or a public defender, to represent them and act as their advocates at every stage of the criminal justice system. And as you can imagine and will read, there is a great deal of discussion as to the advocacy of the court-appointed and public defender as compared to one who has the means to pay for adequate representation, being that the former two are not as effective in the plea bargaining, that is, getting the least punitive damages or sentence. The first interpretation of the meaning of the Sixth Amendment in terms of adequate representation is Powell versus Alabama. This is a 1932 case, and it states, in essence, that if you are accused of a capital offense, that is a murder offense where you can lose your own life, then you have the right to have counsel. And if you cannot afford one, one will be provided for you. But this was only in those capital offense cases. Following that, then, 6 years later, is the Johnson versus Zebret case. And again, this is a U.S. Supreme Court case that established if you are accused of a federal crime, then you have the right to an attorney. But only if it was a federal crime would counsel be appointed for you. Gideon versus Wainwright, a 1963 U.S. Supreme Court decision, is, according to many legal scholars, one of the most, if not the most, significant decision relevant to the processes of the criminal justice system in the 20th century. Gideon is an indigent man who is accused of breaking and entering into a pool hall at night, which is a serious crime, and stealing enough money that made it a grand larceny. So he is looking at 2 felonies, breaking and entering, burglary being very serious. At his trial, he is not represented by counsel, and he asked the judge, "Is that fair?" And the judge said that I will be responsible for assuring that your rights are not trampled upon. Long story short, Gideon is found guilty, and for his age, he was given what amounted to a death sentence. I believe it was 40 plus years before he was eligible for parole, and as a 62-year-old, he was going to die in prison. This case, to me, illustrates why our Constitution is such a profound document. It does work. When Gideon is in prison, he pencils, literally takes a pencil and writes a letter to the U.S. Supreme Court. It is written in very elementary English. He probably had a second, third grade education, but the essence of his letter was, I have not been treated fairly because I did not have a lawyer to state my position. The Supreme Court agrees, and now anytime you are accused of a crime where you can lose a day of your freedom, then you have the right to an attorney. So Gideon versus Wainwright gave anyone who was accused of a felony the right to be represented by counsel. The Anslinger v. Camlin case decided in 1972 by the U.S. Supreme Court solidified your right to counsel anytime you are accused of a crime, be it felony or misdemeanor. The court has continued this interpretation of the Sixth Amendment. Please read Alabama v. Shelton, a 2002 case. Please read carefully the criticisms of the indigent defense system as illustrated in your text, but generally they can be defined as the quality of justice that one receives in comparison of your ability to hire an attorney and your inability, therefore you are going to receive a court-appointed or public defender, which according to much research, in fact the literature is replete in this area, may negatively affect the quality of your defense. As with all rights, you do have the right to waive legal counsel to be provided by the state if you so choose. You may, if you are not exceptionally bright or if you have a background, but I believe the idiom is only a fool represents himself in a court of law, but you do have the right to refuse counsel and you can defend yourself if you so choose. Because there are such negative consequences to one's perceptions of a poor defense, especially the indigent accused who is assigned to a public defender, an individual who may have dozens of cases pending, the defendant may, with the approval of the court, request a new attorney be assigned. However, the court must approve this reassignment. I have been in the courtroom when the public defender or the court-appointed attorney asked the court to be dismissed from the case as well. At the level of appellate review, if you can get your case reviewed by an appellate court and the court does indeed assign merit, that is, they are only reviewing whether or not you may have not received a fair trial, or the judge may have erred in his or her decisions concerning the search warrant or evidence, etc., then the court will appoint you appellate counsel. This also includes individuals who are indigent, and you will have court-appointed attorneys or public defenders who will do appellate work as well. The defense counsel also is expected to follow the ethical guidelines that have been established by the American Bar Association, where the defense of the accused is concerned.